Hello, I'm John Campbell. I'm an elder law attorney working with the Hughes law firm in Denver, Colorado. Welcome to our Medicaid 101 video series. All of the videos in our series are intended to provide only general information on the basics of Medicaid in the state of Colorado. Medicaid laws in other states may differ significantly. Also, our videos are not intended as do-it-yourself guide to Medicaid planning. Each person's situation is different, and Medicaid planning is very complex. You should never try to engage in any type of Medicaid planning without consulting an elder law attorney experienced in Medicaid in your state. The other thing people try to do when they're planning for Medicaid is to use trusts to basically receive assets. They try to reduce their countable resources by transferring them into a trust. Sometimes this works, sometimes it doesn't. Medicaid has some very strict rules on trusts created by an individual or his or her spouse when that individual is getting ready to apply for Medicaid. These are commonly referred to as self-funded or self-settled trusts. And the rules are these. If it's a revocable trust, for instance, if you went to your estate planning attorney years ago and they prepared wills and powers of attorney and a revocable living trust for you, everything in that revocable living trust is going to be considered an available resource because you created the trust, you're the beneficiary. So by putting property into a revocable trust, you really don't reduce your accountable assets at all. As a matter of fact, you can even harm yourself because if you put your primary residence into a revocable living trust, even though it would normally be an exempt resource, it loses that exemption once it goes into the trust. People who come into us for Medicaid planning that have their home in a revocable trust usually find out that they have to take it back out again in order to do anything. If it's an irrevocable trust, that means a trust you can't change it, you can't set it aside, you can't stop it once it's started. Then there's a different set of rules. They say that anything that's in that irrevocable trust that can be used for the benefit of the individual who funded it under any circumstances, and they interpret that language very broadly here in Colorado, then those assets that can be used under any circumstances for the individual are considered available resources. Anything that cannot be considered or used for the individual under any circumstances is going to be treated as a transfer without fair consideration, and it will incur a transfer penalty. The problem is that the interpretation of that language for the sole benefit of is subject to a lot of subjectivity depending on who's reviewing your trust at the state level. And while you may think that you have a trust whose funding created a transfer without fair consideration, and you've planned for that, you may be unpleasantly surprised to find that the individual reviewing your trust sees a way that the grantor of the trust can benefit and may treat it as an available resource instead. There are, however, some exceptions to those rules on self-settled trusts. And actually there are three exceptions. One is called a disability trust. In some states it's also called a special needs trust, a state payback trust, a D4A trust, referring to the section of the federal statute that created it. But it's all the same type of thing. In Colorado we call it a disability trust. And it's a trust that's created for the sole benefit of one individual who is disabled and under age 65. That trust can only be created by that individual's parent, grandparent, legal guardian, or court. And finally, that trust has to contain a provision that states that when that beneficiary grantor dies, any property remaining in the trust has to be made available to repay the state for any Medicaid benefits paid out for that individual during their lifetime. The second exception is the income trust, or the Miller Trust, that we referred to briefly earlier. This is the trust that's used for people whose income is greater than $2,130 a month, but it's not high enough for them to pay for the average monthly cost of nursing home care in their region of the state. By using this income trust, when they fall into that gap, they can still qualify for Medicaid. And we also have to use that when we're doing that crisis planning that we talked about to establish eligibility. It's only used for that purpose. It's not used for anything else. So an income trust, unless you're actually applying for Medicaid with excess income, you wouldn't even use it. You'd have no need. The third exception is referred to as the pooled trust. The pooled trust is very similar to a disability trust in that it is for an individual who is disabled. However, the pooled trust can be created for an individual of any age. The caveat here is that under certain circumstances for individuals over age 65, the funding of the trust may be treated as a transfer without fair consideration. It's all going to depend on whether or not, based upon the amount of money going into the trust, the amount of anticipated care expenses, and the age of the beneficiary, whether the trust can be expected to be used up entirely during that individual's remaining life expectancy. The pooled trust also has that provision that funds remaining in the trust on the death of the beneficiary are returned to are to be used to repay the state, but there's an exception there. If the pooled trust itself has a policy where they retain those funds for the trust, then they don't go to the state, they stay with the trust. And what happens with a pooled trust, instead of being an individual trust for an individual beneficiary with an individual trustee, like a disability trust, this is a single trust with a single trustee, which is a not-for-profit entity. But there are multiple beneficiaries of the trust. Each has their own separate, individual, segregated trust account for their sole benefit. But the trustee is allowed to pool the assets of all those individuals for purposes of investment and money management. Also, there can be third-party trusts. We've been talking about self-settled trusts, but a third-party trust. An individual, other than the person who's applying or their spouse, may create a trust for the individual's benefit and fund it with their own funds, not the individual's funds. Those trusts are not counted as resources by Medicaid as long as they're discretionary trusts. The bottom line here is, if you're looking at using trusts as part of your planning to become eligible for Medicaid, it is essential that you discuss your case with an experienced elder law attorney, first of all, to determine whether any of these trusts will work for you, and if so, which type will be the best for you in your situation.